Hi, I'm Don Bailey. And so, what's that about? Well, you have an idea and you want to manufacture it or have it manufactured or take it to market. How do you do that? What about protection? What about patent protection? We're going to show you how, in this next several videos, how you need to A, get patent protection, B, take it to market, get it marketed, and hopefully give you some ideas about manufacturing. The most important part of that equation, I think, is getting patent protection, assuming that it's patentable, and it may not be. It may be just an old idea, but if it's a good idea and it's unique and new, then you need to get patent protection. In fact, it reminds me of a story about, I was talking about the marketing, it reminds me of a story about a friend of mine that had this great idea for a picture hook. Jim, you know how you want to put 4 or 5 pictures in a row and they all need to be lined up? Well, sometimes you put the nail in the wall and it's down or up, or he had an idea where you can ratchet the hook so it moves up or down. It was a great idea, but the guy couldn't get it marketed. He finally found the right marketing firm, and by the way, it's been successful, and you'll find it in most of the hardware stores. Great idea. So the first video that we're going to do is about patents and patent protection, and why you need a patent, why you don't need a patent. So we're going to bring in Mike from Remarck, who is here in Auburn Hills, who is a great law firm, and this is a guy, by the way, that is not going to take your money and suck you in, so to speak, and then get a few $1,000s from him and then come back and tell you, well, by the way, you need to spend this and that. Now you're up to 10 grand. He doesn't do that. But it's not a commercial about him. What this is really about is how you protect yourself or don't protect yourself for a patent. So let's bring in Mike from Remarck. Come on in here, Mike, anyway. Good to see you.
Nice to meet you.
Come on in and have a seat. So Mike's going to tell us about why we need patents and why we don't. And there are times that we should not get patents and times that we should. Right, Mike?
Yeah, I think it makes sense to start with, what is a patent and what isn't a patent.
By the way, what the hell kind of name is Schaldenbrand? What is that?
It's sort of an Austrian name, but it's a mixture of everything.
It's a cool name. It's a really cool name, if I could ever remember to say it twice.
It's a long name. So.
What happened to Smith, anyway?
Yeah, I should have gone shorter than that.
So you had to go through life signing all that?
Yep.
How do you spell that?
13 letters. I have Schaldenbrand in any form. So.
Anyway, so we've had the privilege of having an association with Mike for several years now, and he's a very accomplished patent attorney, and he specializes primarily in IP, right?
Yeah.
Which, by the way, that's a tech term for those of you that don't. It's intellectual property, right, Jim?
Absolutely.
You know about that? Okay. So anyway, tell us a little bit about why we need patents and why we don't, because we have people out there that have requested information about, do I get a patent, do I not get a patent, and I have several patents myself, and I know the process, but I don't know it from your side. So maybe you can explain it to our viewers.
Yeah, I mean, first of all, there's numerous kinds of patents which most people don't understand. There's what's called a utility patent, and there's a design patent. A utility patent is something that protects something that's useful. That's why it has utility, right? A design patent is something that protects a design, something that the aesthetic part of it, something that looks good. So oftentimes in your business, you'll probably have both. You'll have things that perform functions, and you'll have things that look particular and look attractive, and for that reason have perhaps more value over a competitor or some other reason. So you ask, why would one have a patent? Why would one get a patent? It's just to protect, one reason is to protect a source of revenue, right? If you're selling a product, absent some form of protection, intellectual property protection, people can just go and create that product and undercut you if it's cheaper, right? So you want to protect your profit margins, you want to protect your revenue streams.
So I come to you with an idea, and I say, gee, I've got an idea for an automotive air cleaner that I want to attach to a fence. And you checked it out and you said, there's nothing like it, right?
Right.
There's no patent out there like that. So I could get that patent, right?
Yeah, I mean, that's one of the steps. In order to get a patent, you just can't get a patent on anything. It has to be new, and in fact, the word is non-obvious. Non-obvious is really not a word, but lawyers make up words all the time. So non-obvious is a word now. And it has to be new. So you said, oh, there's no patent out there. So if it's new and non-obvious, and has some utility, there's some other requirements. But essentially, if you come up with a new idea, a new way of doing things, the better mousetrap, you can protect that with a patent.
Now, you don't get involved in this, but on the marketing side, the idea of an air cleaner attached to a fence, while it may be patentable, what's the marketability?
Right.
That's not your area of expertise, though. But
no, that's not. But that's a very good point, because you asked earlier why one would get a patent and why one would not get a patent. So I gave one example of you'd protect a revenue stream. Well, something that's not marketable and not of interest in the market, you really don't need to protect that revenue stream, because there is no revenue stream. So an automotive air cleaner or an air cleaner attached to a fence probably isn't all that useful from a business perspective. But that's not. You're right. As an attorney, we're a special tool, right, in your toolbox. We provide certain services. It's not to make you money, it's to provide you legal advice. If you asked us to do that, well, I might question that idea. But nonetheless, we can help you with those, getting the patent, obtaining a patent, and providing legal advice.
All right, so now let's say I've got the patent and somebody violates the patent.
Sure.
Now what?
That's a great question. So the term is infringe a patent. So you're using, they basically copied the thing that your patent protects, and what can you do? And there's so many different options. It's very difficult to go through them all very quickly. But in the worst case scenario, what one would expect, is you would go to court to try to stop that person from infringing your patent. You would be able to stop them from making that product, selling that service, whatever the patent covers.
So now let's say that the court says, we're not ready to prevent them from making the product, but that would be an injunction, I guess. Is that correct?
Yeah.
So we're not ready. The court says we're not ready to give you an injunction, but you need to do more work. You need to do more background work. The court says we want more information. Now we're running up a fee as time goes on,
Sure.
right? So to protect that patent could get very expensive, correct?
Yeah, it does get patented, and that brings up a very good point, because I gave the example of there's many different things you can use a patent for, and I gave the example that everyone thinks of, which is going to court, suing someone, and anyone who's been involved in any lawsuit knows it gets pretty expensive. And but there are other ways to utilize your patent. For example, you can use that patent if you're perhaps selling to one of your customers, and now you're competing, and your competitor is trying to sell a similar or the same product that infringes your patent. Well, you can let the buyer know that, hey, I have a patent that covers this, and if you purchase from this other person, their source of product or parts may stop via injunction and so forth. So there's other values. You can also obtain patents, and your competitor, the competitor that's infringing your patent, they might have patents, and you might be infringing them. It's not a patent on one thing, right? There can be, in fact, there usually are lots of patents on one product. I mean, look at a car. There's hundreds of patents, thousands of patents. Even on small items, there could be many.
You brought up an interesting point a few days ago when we were chatting about doing the video. And you mentioned some of the major corporations and why they don't like to have patents sent to them, or ideas sent to them.
Yes.
Explain that, because that was really an interesting point.
Sure. So especially for someone who's not in a business. So if you're just an individual, or maybe you have a job, but you come up with ideas. I mean, people run into problems every day, and that's sort of what an invention is, right? It's not always a time machine or something groundbreaking, right? It could be just a solution to a problem. That's what I always say. Anytime you have people running into a problem and then making a solution to that problem, that's an invention. So oftentimes people get these ideas and they say, hey, this is really great. I have a great idea for, let's just use again, because we're in the Detroit area, let's use autos, right? I have a great idea for a heated mirror, right? Now that's old, but back in the day it wasn't old. So they say, hey, let's put a heated mirror, and they send an idea to a supplier,
one of the big three,
whatever, and oftentimes those companies are way in advance. As you would know, as a business owner knows, what you have in the market is not what's in your R&D shop, right? You're not putting things out in a day. You're putting things out years in advance. So oftentimes those companies don't want those ideas because they're working on them independently. But even if they aren't, they're this big, huge company, and you're a company, and an individual looks very sympathetic into a court, and you don't want to be accused of stealing a product, a product that you had. I gave you that. We'd get that in there. You'd look at it, and most companies won't even look because they don't really want to know. I know that's sort of not what you think, but
I can understand that.
Most people don't understand that. They think I have a great idea for. I mean, let's say it's I won't give example company names, but it's a home service or home product company, right? Like Kleenex or something like that. Hey, I have a great idea. Why don't we put lotion on a tissue, right? And Kleenex is like, well, we don't want that idea. And so people think I have this great idea. I'm not going to start a paper company, but I'll send it to Kleenex, and I'll do this idea, and then maybe they'll give me some money, right? So you'll see the people that get that idea. I wouldn't recommend. As an individual sending it there, and as a company, I wouldn't recommend taking too many of those ideas because it can look worse than it is, right? Because Kleenex can say, no, thank you, we're not interested, because they already prototyped that and they're going to release it in 6 months.
And nobody knows it.
No one knows it.
So then they come out with a product and somebody says, wait a minute, I had that idea a year ago, and now they're copying me, right?
As a patent attorney, I can guarantee you that any person I meet, they always says, I had the greatest idea, and then someone came up with it 6 months later. I get that at any party I go to, any gathering with new people, that you're a patent attorney, right? So I mostly tell people I'm an engineer. So
that's great. So now, what else was there? I think we're going to cover some other issues, weren't there? About marketing, maybe, or
yeah, I mean, we talked a little bit about common mistakes because we were talking about like when you'd get a patent or when you wouldn't get a patent.
What it was. Yeah.
And so as a business owner, like what are common mistakes that I see business owners make and that you may make if you're not aware, right?
Yeah, I have a great idea, and I tell all my friends about it.
Yeah.
And maybe I make the product and I show it to a bunch of people, or I send it out to them and let them try it. Bad idea, right?
Yeah, I mean, it gets complex, and let me also start by saying that patent laws are different in different countries. So let's talk about the U.S. because we're in the U.S. And each patent only grants you regional rights, so only in those specific countries. There isn't, right now anyways, I don't think there ever will be, a worldwide patent, although that word is thrown around sometimes for various different things that can be turned into regional protection. But in the U.S., you have a period of time after you disclose something to go and get patent protection. It's generally speaking a year. So if you go out and you have this great idea and you go to your customer and say, like, I have this product you come out with, what do you think? You think you'd be interested in this? Just generally speaking, and your customers look at it and say, 8 of 10 say, yeah, it's a good idea. Well, that might be worthwhile for you further developing, right? But now you've gone out and told a bunch of people about your idea, and let's assume that there's only one level of disclosure. You either told them or you haven't, as opposed to you told them something but not all the details. But let's assume there's only one level. You've told them your idea. Well, you may be, in fact, you are precluded from getting a patent in a lot of countries, and in the U.S., that also starts a time clock where you have to apply for a patent within 12 months, or you won't be able to get a patent. And so, that's the normal way and that's the normal way your business works, I'm sure. And not maybe that prototypical example, but another example I see is if you're working with a customer, they run into a problem. Hey, we noticed this issue, and then they present it to you because it involves your part or your part with another part or their part, and so then your folks will go and come up with a solution to that problem, or either with them or without them, right? Well, again, as I said earlier, that problem/solution, that solution is an invention. And so when you're exchanging information back and forth like that could be a problem for you disclosing it and not being able to get a patent.
What about, and I know I'm kind of jumping around here, but what about a provisional patent? What is that?
Okay, so that's an interesting question. A provisional patent, you'll hear that term. It's actually not a patent. It's a provisional patent application, but essentially what it does is a quick way to get something on file that doesn't have to, although I recommend it does, comply with all the formalities that a patent application normally has. If you've ever seen a patent application or a patent, you know, they're very rigid. They have drawings at the front, usually, almost always. They're black and white drawings, there's no color on them, things like that. With a provisional application, you can file something really quickly. Usually, your attorney can put it together relatively quickly. You put it on file with the patent office, and then you sort of have a year in which to take that application and make it more formal, make it more like a normal patent application would be. And so those come up. It's a great question. It's not off topic at all. Those come up where your customer's got this problem, this urgent problem. Is there never an urgent? There's always urgent.
Always urgent, right?
That's redundant, right? So a problem is urgent. So you have your people working on it. They come up with a solution, and like, what do they immediately want to do, are expected to do? Tell the people, right? So oftentimes, and it's not good for our life and our families, but we'll get called on a Friday. It says, we're having a meeting Monday, and like, we just finished this, and we're disclosing everything, you know, 9 a.m. meeting at our customer's
We need
location.
protection now.
And so we have to go and prepare this application, and realistically speaking, although it is possible, but you know, you can't put everything in great order in that time frame.
Sure,
right?
sure.
It takes time to make a good soup. It takes time to make a good patent application.
Well, I like that. It takes time to make good soup.
Yeah. So
Or chili.
Or anything.
Yeah.
So you know, it's got to simmer. So so the patent application has to simmer, but you don't have that time. So we'll get called in to put something rough together, and you'd file it provisionally because, again, the patent office doesn't really look at it. They don't look at it at that time, and it just sort of creates, I call it a placeholder. There's a placeholder there. Now you have 12 months from that date to let it simmer and more develop, and you can meet the formalities of the application. There are some risks associated with a provisional patent application, but certainly there are times when you need it. And the example is what I just
That's an
gave.
example of when you really need a provisional. That's interesting.
Yep.
And patents are good for how long?
Well, again, that's different by country, and it's different based on what kind of patent it is. So in the US, right now it's 20 years from the filing date, but the filing date is the application filing date, and so you technically don't have a patent until it issues and grants.
And that could be a couple years, right?
It's typically a couple of years. I mean, it could be a decade or more. That's unusual now, but it's not typically 6 months. It's 2 to 3 years. So you're looking at a period of time for, you know, 15 to 18 years, but you also have to pay some fees to the government, of course, to keep that patent in force.
Annual?
In the U.S., in most countries they're annual. In the U.S., there's 3 time periods. It's 3.5 years, 7.5 years, and 11.5 years from issuance.
So what would the cost be typically, if there is such a typical question as to what would a patent cost for, let's say, some mechanical device?
Okay, that's a good question. So there are attorneys, there are people who will quote like an end-to-end cost. But as you'd imagine, things can go all different ways. It's very difficult to provide a typical cost. And you said a simple mechanical invention. I mean, if you're looking at just the application part or all the way to keeping it alive for 20 years, I mean, you're talking thousands, probably more than likely tens of thousands of dollars. You know,
from cradle to grave.
From cradle to grave, and that's exactly the terminology that some people use. It would be unusual, I think, depending on what kind of company you are too. The fees are different too. If you're a small company versus a large company, there's different fees. But if you're not willing to spend $10,000 or more, then you probably don't really want to apply for a patent.
So there you go. Not the kind of thing that you want to get involved in unless you really have a terrific idea, right?
Right.
And
well, you'll find, I mean, I don't mean to interrupt you, but you'll find attorneys, and this is one of the things I said we talked about last, like what should you do, right? Like what would you run into? And like one of the things you have to do, just like with anything, is find the right person for your needs. And a patent attorney, a good patent attorney, will tell you all these things. You will find a patent attorney and they won't talk about cradle to grave, right? They'll kill you with a million pinpricks.
Kind of reel you in.
Right. So it's $1,000 here, and then it's, oh, there's extra, and oh, this came back. And so like you got to understand the process. A good patent attorney will go through, even any patent attorney will go through and explain to you the process and explain to you that there's different costs. And depending on how things go, things cost more and things cost less. I mean, we provide a service, and it's usually hourly. So
So I come up with an idea and I give it to you, you put it together, you send it to the patent office. Now it has to go to an examiner, I guess?
That's exactly right, yep.
And then they look at it and they try to find, well, I guess you'd call it art, similar art?
Yep.
Is that correct?
It's prior art, but yep.
Prior art, okay, so they want to find prior art. And then they come back and say, well, this patent is okay. You have 5 claims here, 10 claims, and 2 or 3 of these claims are old art or prior art, so we're not going to give you that. And then you have to argue that again, correct?
That's right. I mean, that's exactly right. They're designed to go out and figure out what's out there, what has already been invented, right? That's the new and non-obvious word we talked about, right? So they go out, they do a search. They're generally skilled in that area. They've usually worked there for a number of years. They certainly have technical training at a minimum, and they're working under someone who's been there a lot of years if they're new. And they go and they say, what's called examine, because they're examiners, your patent application versus what's out there, and then they say, hey, that's not new because look at this, or hey, that's obvious because of this and this. And then you can argue with them, and oftentimes you change course, not change course, but you'll amend your claims is what the term is. So maybe you try to get really broad protection, but then a small aspect of that protection is not available because it's old or obvious. And then you sort of go through, and it's not truly a negotiation, but that's probably what's most analogous is to say in a negotiation with an examiner.
Hey Jim, did we miss anything?
I have a question. Say I have a machine tool, a very precision tool, and it's a very simple tool, and I came up with it, and I don't see it on the market anywhere, and I want to bring it to market, but I want to protect myself from, say, somebody overseas in a low-cost country of copying my product and putting an inferior product in the marketplace that looks just like mine, but it doesn't have the tolerances, it's not as tightly held. Is there a way to protect myself from that?
I mean, that's a great question, and I'll tell you that this is not a hypothetical, right? This happens all the time. So the answer is yeah, and the patent is a perfect example for what you do that. The one issue that you brought up is the overseas issue.
I did that on purpose.
Yeah, and so the question is, if the sales are going to be here, you can obtain a patent here. Technically speaking, in the U.S., it's a patent allows someone to allows a patentee, a person who has a patent, to stop someone from making, selling, offering for sale, or using their invention in the United States. So an overseas person can, let's just give an example of Lithuania. Doesn't really matter. If you don't have a patent in Lithuania,
I'm half Lithuanian.
I'm not picking on them.
Well, I'm just picking on Lithuanians now.
Okay, let's go somewhere else. No. So this other country has someone making this product and they're selling it in France, right? You have a patent in the U.S. There's absolutely nothing you can do about that, and perhaps that's okay. Were you going to sell in France? Maybe you were. If you were, that's what a more broad patent protection would allow. But let's say you have this Lithuanian company making this part. They're going to sell to this manufacturer in Mexico. Mexico is going to incorporate it into a product. That product will be imported into the U.S. That importation and sale is an infringing act.
So it's the liability would fall on the importer, the user, and even the distributor, the seller. Is that correct?
Yeah, I mean it's complex, but yes, the answer is yes. You can have multiple people infringing. So you can have someone making it, and then you can give it to a distributor. I mean, here's a classic example. You have a manufacturer that doesn't have a distributor; it's a separate company. That making it, that's an infringement. Selling it, that's an infringement.
It's a lawyer's dream.
Infringement, right?
It's a lawyer's dream.
I have another question.
They get to sue all these people.
No, only the ones with the most money.
There you go.
That's what happens.
The deep pockets.
That's truly what happens.
Yeah.
So.
What happens if we go through that? I get my patent, and somebody goes behind me and they start flooding the market with inferior products, and I don't even see them for 5 years. I don't even realize they're there, and then I find them 5 years later that somebody's been selling a copy of my product. What do I do?
Well, again, the prototypical example is to go to court and you can sue for damages. Just like if someone was intellectual property is sometimes analogized to trespass. In fact, back hundreds of years ago, that's what they would call it. So if someone's walking across your property every day and you don't know, and then you find out there's a path on your property, right? And you're like, whoa, you've been trespassing on my property. Well, what are the damages? Well, you got to fix that path. You've worn a path.
Yeah, that's a good
right?
point.
So you get some money back to reseed or resod the grass there.
Is there a time frame?
There is a time frame. It's very complex because it has to do with knowledge and other things. But generally speaking, there are exceptions, but the U.S. allows you to get damages from up to 6 years in the past. So if they've been doing it for 10 years, you can't get 10 years of damages, but you could get 6. And then there are some exceptions, because if you didn't know about it, that's easy. But if you've known about it and sort of let them walk until they've really destroyed your property, right? Or you let them accumulate a bunch of damages just to sue them, like they may have defenses, but that's probably too complex.
Yeah, interesting. Now you probably know the answer to this, but it seems to me back in the 20s, 1920, 29, somewhere there, weren't they talking about, wasn't one of the government officials talking about closing a patent office?
Yeah, in fact...
Because there was nothing left to invent.
Yeah.
That's true. True story,
True
right?
story. In fact, I mean, I've heard it told different ways. It may be apocryphal, but I don't think it is.
Congressman or somebody?
It was Abraham Lincoln's Secretary of Commerce, I believe.
Was that who it was?
And I could be wrong about that, but that's how I've heard it most likely. And they said, well, we're spending all this money having this patent office. We're having all these employees, all these highly trained technical employees. And essentially, everything that's been invented has already been invented.
We're done. There's no more inventions, so let's close the patent office.
We don't have to spend the money on the patent office, because any government, right, it's always about cutting costs, even back then. And so they were going to cut the patent office. Now, the patent office is a huge moneymaker for the government, and they actually... I think things have changed a little bit, but they used to try to take that money and use it elsewhere. But back in the day, patent office cost money. Right now, government makes money off patent office.
So you're probably pretty glad they didn't close the patent office.
Well, I mean, I could have done something different. Right. Yeah, I'd be out of a job right now. So.
Yeah, you'd be maybe a veterinarian or something.
Yeah, sure.
Did we miss anything, Jim, or is that pretty much it? Does it cover it?
I think that's pretty much it. We probably are going to have more segments on how to bring products to market and so on. We didn't talk that much about this right now. This was more of
the patent themselves. Yeah, sure. Well, it's really been informative for me. And anything else you might want to add, Mike, or did we cover most of the ground?
I think we covered everything. The only thing I would say is just sort of a reiteration of what I said earlier, which is, if you don't know, you make a lot of mistakes, right? We talked about a little bit of common mistakes, disclosing it to others, etc. And it makes sense to meet with an attorney, a patent attorney in particular, because all attorneys don't do everything. So a patent attorney would help you with patents, and have someone think of ideas for you. Or when you think of ideas, think, hey, maybe I should call an attorney to look at this and talk to them for a very short period of time, because you don't want to make the mistake. And oftentimes, I think we talked a couple of days ago about who invented the light bulb, right? Edison, and Tesla, and all this issue. So oftentimes it's not the genius inventor sitting in a lab inventing sliced bread for the first time ever. There's a bunch of people that are working on this and coming up to different problems independently of each other. And I would submit to you as a patent attorney that the person with the best patent attorney may be able to have the market, as opposed to someone who came up with it, quote unquote, first.
I think in closing, any of you out there that may have a great idea or think you have a great idea, and Mike brought it up and made a very clear point of it, that there's a tremendous lag time between the day you see it on the market and the day that they're developing the product, which could be 3, 4, 5, 7, 10 years in advance. Who knows? So you may have an idea, but it could be in the pipeline already, even though you don't see it in the marketplace. So you come up with an idea and you go to a patent attorney and say, well, I've got this great idea, and next thing you know, a year or 2 years later, it's already out there. You've wasted your time and your money and your energy. So you need to be careful. There's a lot of smart people out there with a lot of great ideas that are working on nothing but patents and new ideas every day. So for you to be that smart and that special to come up with an idea, not that you can't do it, because it happens, but it's got to be pretty unique and very, very special. Would you agree?
I would, and I would say that it's an incremental process, right? People talk about the stroke of genius or the light bulb coming on, and even patent law talks about that. It's called conception, right? You conceive of the invention as if there's like all of a sudden a lightning bolt hits you, but it's not. It's a lot of hard work, and oftentimes getting the attorney involved at the end is too late. And that's sort of what I want to reiterate is the meeting with your attorney, finding an attorney, considering the ideas, and then keeping them as part of the process. I mean, that's what we try to do for our clients, is try to be part of their process. It doesn't always work. They don't want, I mean, engineers have jobs of being engineers. Sure. They don't have the job of talking with attorneys. But if you keep us in the loop, or your attorney in the loop, it'll help a lot. And it could be wait. It could be not wait. But if you wait until you've talked to every customer and you've prototyped it and you saw what you can make and the profit's worth it and everything, well, that's usually a year after you've disclosed it to someone. And now you can't.
So, Remarck Law in Auburn Hills. And by the way, Mike, I have an idea. Can we go talk?
Sure, absolutely.
Mike, thanks so much for the input, and I know our viewers are really going to appreciate it, and they're going to have a better understanding of what patent law is all about. So thanks so much for joining us.
You're very welcome. Yeah.
And thanks for watching.